Mr. Adam. Okay, are you ready to start? Are you comfortable with the medium you're using?
Yes, we can start anytime.
Okay. Good morning, Mr. Adam. I am Morgan, partner of Naufal and Associates. This would be my co-counsel. Uh, would you like to introduce yourself?
Hello, Mr. Adam. My name is Nurnamirrah. I am one of the partner of Naufal and Associate as well. How are you?
Hello, I'm fine. So nice to meet both of you.
Okay. First of all, we would like to apologize for being unable to perform a face-to-face meeting. As you are aware of the current COVID situation, so we have opted out to go with the Zoom meeting, which is a much safer alternative. But anyways, we are extremely pleased that you chose to consult with Naufal and Associates. All right, Mr. Adam, before we start with the consultation, we would like to assure you that our conversation today will be strictly confidential. Please be rest assured that any information that has been disclosed in this session will not be disclosed to anyone outside of this meeting.
Okay. Actually, I have a question. So let's say I want to, uh, let's say I would like to discuss with my friend or maybe my employee about this matter. Can I do that?
Okay, I don't think for now it would be advisable to do that. It is better for you to keep it confidential with yourself. I think it would be okay if you can discuss after you have decided further on whether you would like to go with litigation or another alternative.
Okay, I see.
Okay.
Thank you for the
Next, yes.
clarification.
Okay. Next, Mr. Adam, I would like to inform you that today's consultation session comes along with a fee of 250 ringgit. This first consultancy fee will be charged in accordance with the Kuala Lumpur Bar Committee regulation. Okay. You will pay once the consultation ends. For further sessions, just in case you would like to consult us further after this session, we would be charging a fee of 500 ringgit per hour. And moreover, any transportation, accommodation cost, or legal documentation fees incurred for any legal service that we offer you in future upon your request must be fully covered by you.
Okay. So maybe you can inform further on the charges later on. So I think we can continue our discussion.
Okay, yes, Mr. Adam. We have actually gone through some of your information just now. We confirm that there have no conflict of interest between you and our other clients. So we shall begin now, Mr. Morgan.
Yeah, sure. Are you okay, Mr. Adam, to begin now?
If there is no problem, okay, never mind. Just continue.
All right. So, Mr. Adam, may we know what brings you to our firm today?
Actually, I would like to claim on breach of confidence regarding about employees. Let me start first on the fact. Actually, I own a company, Phrasaddha Berhad. It's a company specialized in software development. But last time, about last month, when I found out that my product, the program that I've been developed for the past 2 years, being copied, the one IT company also specialized in the same field, which is the software development. So by the way, my program, this software program named BPM. So actually, what they did, they even copied hundreds of diagrams and drawing from my program, which I believe that they had infringed some of my intellectual property rights. So later I realized that this company was established by my ex-employees, where they just resigned about 6 months, something like that. I believe they have used my confidential information regarding on the what we call it the program, the BPM, to set up their own company, and they used it to develop the same program as mine. And they also aim to solicit and to take some of my client also, my customers. So I believe it was a breach of employment agreement that have been made previously. So I come here to seek seek for advice regarding on what should I do now legally, and how I need to do to safeguard my company's right.
All right, Mr. Adam, I get the overall picture on your concerns. In order for us to help you effectively, we hope to know every single detail which involves in the series of events to make sure that we do not miss a single point. If, let's say, we are going to represent you as your attorney, we do not want to be facing these facts that you have not informed us suddenly during the process of the litigation, which would actually cause further trouble, and also uh, it would actually contradict with the arguments that we will be placing in future. So I just want to inform you that please be honest with us so that we can give the best advice that we can to actually solve your problem.
So is
Yes.
that this session? Uh, do I need to reveal all of the facts, or I can come out later on with, because
Uh,
this session, if I'm not mistaken, is only about 30 minutes.
mhm.
Mm-hmm.
Later on, I gather some information also to inform you guys about.
Yes,
Possibly.
please. Adam, please start from the employment agreement.
Okay, so sure. Okay, we start from the employment agreement. I will give you a copy. So the employment agreement
Mm-hmm.
that me and my employees assigned clearly says that the employees are not allowed to join or set up their own business to compete with my company, Phrasaddha, even during uh, their time as an employee, also after resignation. And they also could not reveal or misuse any confidential information regarding on anything about our product or service. But eventually, they did, both of them. They breached this kind of clauses.
Okay, Mr. Adam, do you have the agreement with you today? And is it with you now?
Uh, yes, I bring one of them, but
Mm-hmm.
uh, I, if I'm not mistaken, the three of the employment agreements are the same regarding on the clause. Everything is there, and I've marked this with the clauses with a sticky note.
Okay, that's good. Actually, I saw the non-compete clause and confidential clause. Are they capable persons to understand the agreement, which means mentally and emotionally?
Uh, can you a little bit clarify about what actually is capable to understand?
Which means that at the point that you perform the agreement with the three employees, they were of sound mind. Okay, they had knowledge that they were actually signing an agreement based on these clauses, the clauses that you have stated before, and moreover, they were not actually forced to go into an agreement, which would not be good for your side if they were actually forced to enter into such agreement. And moreover, we would also like to know whether that they were actually emotionally stable, which means that they were fully aware of what they were doing at that point of time when they actually signed the employment agreement. This would actually make a lot of things differ. If it is of they were of sound mind, then it will be okay for you. But if not, then it will be complicated with your
Okay,
policy.
if that's the case, I guess I believe that they have the capability to understand the agreement. And when we sign the employment agreement, I have given them enough time to read through the agreement, and I also point out and highlighted two clauses. And I also believe that our my employee could easily understand the agreement since we constructed the agreement with simple English. It's easier to understand. So I have a question to both of you. Are these amounted to breach of contract?
Um, we cannot really affirm with you right now, actually, Adam. So we will need some time to sort this out later. So let us continue with the data that you claim they had copied the business from your company. Have you ever registered your program under any intellectual property registration, such as copyright, patent, or trademark, Mr. Adam? Have
Okay.
you?
Actually, my company has used up 2 years
Mhm.
uh, period to develop this computer software they call BPM. To safeguard this company artwork, actually we have decided to register previously on a copyright ownership on this software. We registered it on my IPO. We already complied all of the requirements. So this was also made known to them that when they were still employees in my company. I think it's not fair for them to use our diagrams and figures to produce the same product, the same program that we work endlessly throughout this the 2 years. To me, is they already take this for their own advantage, and all of my hard work together with my team is like being wasted. They just simply become like free riders and take all of our works for their own benefits. Um, we also had highlighted previously to them that anything about BPM should not be disclosed to anyone. It was clearly an infringement on my to my copyright.
Okay, Mr. Adam, we understand the situation that you're facing now, but I would like to also inquire whether they were actually actively involved in the development process of BPM. When they were in your company, were they actually involved in the development process of BPM, or were you the sole one to develop the software?
Yes, yes. Actually, they are all of them. Actually, they are important. They are people very important to our company previously. They hold position of business analyst, professional service engineer, and also one of them are software engineer also. They have full accessibility to the confidential information because they work directly to this project previously. So they also have the access for all of those diagrams and drawings.
So, meaning that previously, when they were working in your company, they had access to all your company's diagrams and figures freely. And after they left, they started up their own company. They copy and use the same data from BPM to come up with a similar product. Is it? Is it like that?
Yes, it's true.
Okay, Mr. Adam, did the company manage to solicit any of your customers? Were
Uh,
they able to, as you said before, they had copied your software, as you claim. Uh, did it actually affect your customers in any way, which means that your customers will actually stop taking the software from you and went to their company?
I could not, so I'm not so sure about that because they just their own company. But also, this will be advantage on the part of the company because they can offer lower price for the program since they did not have to spend a lot on the research and the process expenditures and so on. Because simply they just copied our data and all of our hard work. So I'm very afraid that the customers might be confused between our program and that. So actually when I come here, one thing come up with my mind is whether I can sue them, all of them, even with the company
Mm,
also.
okay. From the conversation just now, we found that there are some powerful arguments to support your case. But we need to examine first the employer agreement if there is any mode of settlement dispute clause. If the mode is stipulated there, we need to adhere with the process. However, we always recommend our client to pursue for mediation first before commencing action to the court. This is because from peaceful settlement agreement between the dispute party will result in a win-win situation, and it preserves the good relationship between you and also your ex-employees. But then the disadvantages of this litigation, this is a very long process and the fees may be very expensive sometimes. So when there is a chance that the claimant may not gain, sometimes they don't have a chance to gain anything from it in the end.
I think that is a good alternative because previously I've never know about something like meditation and so on. So I guess I need to have a time to consider the choice just now. If let's say if I want to go for litigation, I want to sue them, take the action to the court. Uh, what do you think about this case? Whether can I win?
Mm, we actually cannot assure you right now, 100%. But of course, Naufal and Associate will try our very best to help our client. And for the moment, we have understood your situation and have taken note on the possible arguments which can help your company out. But we need some time to do research for that first.
Sure. Anything I need to do for this moment?
For now, we need you to provide us with some more documents, including the employment agreements, all documents related to the development of your software BPM, and as well as the copyright registration in the next consultation session. Uh, just to ease your understanding, I think I'll be providing with you with a list later on, so
Okay.
that you can organize the documents that we will need.
How do how can I what is the method on the next meeting? Are we going to conduct in online meeting like this?
Preferably, all of us would like to conduct a face-to-face meeting, but assessing the situation now, as you know that the COVID numbers are on the hike, I think it would be better if we actually perform an online session. However, if there are any changes in the meeting plan, we would be sure to inform you first about it. So if we decide on conducting a face-to-face meeting, but after assessing the situation now, we would definitely inform you, Mr. Adam.
For the document,
Yes, Mr. Adam.
okay, for the document just now, uh, where do I need to send?
We would be providing you with, Mia will be providing you with business card. So you can either contact us, which means you can email the documents to us, or otherwise, if you would like to provide us with a hard copy, you can actually post to our firm directly.
Okay, thank you for the clarification. I will do.
Before we end the consultation,
Okay.
do you have any final questions?
So, okay, maybe we can discuss a little bit about the fees just now. So,
Mm-hmm.
for this starting, is there any other cost that incurred or any fee that I need to pay?
Uh, as for now, it will be just for the consultation. The charges will be 250 ringgit. But in future, if we would be preparing any type of legal services for you, then the charges will be different. And in the next meeting, the charges will be 500 ringgit per hour. That we would like you to take note on that.
So, uh, should I pay now? Can I use Maybank to you to pay to you guys?
Yes, sure. We accept the
Okay.
online transfer method.
Can you later maybe after this
Mhm.
maybe you can give me your account number so I can
Sure.
transfer the money to you guys.
Yes, yes, Mr. Adam. Okay.
Yeah,
Any
we
more?
will assist you to our club later for
Okay.
the payment.
Okay. Thank you.
Mm.
Okay, any more queries, Mr. Adam?
I think maybe that's all for today.
Okay. Thank
Maybe
you.
if I have any question to you guys, maybe can I call you or maybe WhatsApp? Which
Yes.
Yes, you can contact me or Mr. Morgan anytime you want. You can WhatsApp us anytime you want.
okay,
No
thank you.
problem, Mr. Adam.
Okay,
All right. Thank you for today, Mr. Adam. And we really hope to see you in the next meeting.
okay. Thank you also. I really appreciate your work because previously I contact some of the firm and they didn't even uh, entertain me. So luckily I found your firm. So I just want to say that thank you for your hard work today, Mr. Morgan and Miss Namira. I hope you enjoy your day. Thank you so much and goodbye.
Yes. Goodbye. Thank you, Mr. Adam.
Okay, goodbye. Have a good day.
Right, Mia. All right, Mia. Based on the discussion that we had with Mr. Adam just now,
Yes.
I think it would be better if we discuss in detail about the issues he is facing and how we can tackle his case.
Yeah, sure.
So, based on the case that Mr. Adam placed forward, I
Mm-hmm.
found that there are three issues from the conversation just now.
Mm.
Firstly, the non-compete clause and confidentiality clause in the employment contract and the infringement of intellectual property rights. So, what is your opinion on the matters of the contract since you are specialized in this matter?
Yes, Mr. Morgan, I agree with the issues to be identified. For the non-compete clause, it was obviously a violation to Section 28 Contract Act 1950. The law does not allow any restraint of lawful trade, so I think Mr. Adam has have failed to claim for breach of um, contract relied on this clause. I remember on an obiter dicta judgment on the federal court case in the case of Vision Vision Cas Sedang Berhad versus Din Cas Melaka Sedang Berhad had affirmed this. Hmm.
All right, I think
Yeah.
that's the obiter dicta judgment in this case of Vision Sendra Berhad versus Dynakas Melaka Sendra Berhad can be used for the issue of claiming for breach of contract.
Mhm.
So that's I have noted that. So for confidential clauses, I think it was a clearly a breach because the opposing company, which had the three ex-employees of Faro, had actually copied all the diagrams and drawings of Mr. Adams' product,
Mhm.
which shows that their product similarity is very high. Means that the software that developed by the ex-employees is almost exactly the same as BPM.
Yes, agreed. But there must be specific evidence as to what kind of confidential information being misappropriated by the opponent. This was also stipulated in the federal court case I mentioned just now. But I still need to examine the relevant documents provided by Mr. Adam to sort this issue out.
Okay, for that, I'll be sending the list of documents that we will need
Mhm.
to further proceed in this case. So I believe Mr. Adam will be providing us with the documents in near future.
Mhm.
So meanwhile, for the infringement, I think we may be able to claim for damages because uh, as per what we have heard from Mr. Adam, the confidential information had been copied and was actually misused by the opponent, in my opinion.
Mhm.
So if we want to refer to a decided case, I think the case of Juris Technology Sdn Berhad and Nutsoft M Sdn Berhad versus Fu Tiang Sin and five others. I believe the precedent was quite similar to the case of Mr. Adam. So maybe
Yeah,
we can
that's good.
do prior reference to this case.
Yeah, we should do further research for that. I will focus on the employment agreement. Could you please work on the issue of the infringement of copyright?
Yes, sure. I will work on the issue of infringement of copyright.
Mm-hmm.
So for the preliminary interview,
Mm-hmm.
I believe that our client, as far as I know, he could only claim under copyright. Since if you want to bring the action under patent, the issue is the computer program has never been registered under my IPO as a patent.
Mm-hmm.
Furthermore, if Mr. Adam intends to register a patent, our client actually needs to prove that there is an inventive step. But anyways, I
Mm-hmm.
will still do a further research if there are other IP rights available for our client's claim,
Mm-hmm.
so we can actually provide better for Mr. Adam as he has approached Naufal and Associates.
Yeah.
So if there's nothing else, I guess we should end our discussion.
Yeah,
And
no problem.
soon after that, we can come up with a research write-up for our client's case. So after we have proceeded with the research and stuff, and once we are done, I think Mia, you can please arrange our next appointment with Mr. Adam.
Yeah.
So thank you, Ms. Namira, and have a good day.
Yeah, no problem. Thank you. You too. Have a good day, sir.